Everyone. First, I'm Stacey Douglas from U.S. Title, and Corbin Beck here, as Yvonne mentioned. We also have Mike Smith, who is our instructor and our counsel for U.S. Title, and I'm super excited to be here with all of you on Zoom. It's so nice to see so many faces. And this topic is on bankruptcy, and he is amazing in his knowledge and experience, and so I'm super excited for him to share with you all the information in this class. How we are going to work things is, if you do have a question, I know Yvonne mentioned this, you can either do it through the chat, type something, just type in saying you have a question, or raise your hand through the little icon that says raise your hand. And then Corbin and I will be watching out for that. And if there is a little bit of a delay, don't worry, we'll catch you, and we'll make sure that Mike answers any questions that you might have. Don't forget to unmute yourself as well if you do need to interrupt for any reason. And then as far as getting your accreditation for this, I will need you to send me your phone number, license number, and email address. I have posted it in the group chat. If you see the group chat on the right, raise your hand so I can make sure everyone sees that, since you're all muted right now. Good. Okay, so that's where you're going to ask your question, or you can just say I have a question, and then we'll call on you and interrupt. But if you'll see my email address there, if you'll just make sure to send me all your information, then we'll make sure that you get the credit for this class, and then we'll also send you a confirmation within 48 hours to just confirm that your credit has been banked. If you have any questions, you've got my contact information as well. I'm going to put my phone number on here. And then
Stacey, maybe send your email again. Some people aren't seeing it, so maybe just send it one more time.
Did that come through?
Well, nothing yet. Is it to everybody? Do you have it to everyone, or do you have it to someone specific?
Yep, I have it to everyone. I just
there you
posted
go.
it.
I see it now.
Okay. Everyone, can you see it now, everyone? Let's just have everyone respond on the chat. Perfect.
Stacey, did you tell him about the passwords and that I cannot give it to him?
I'm just about to that. So
Okay.
Also what we're going to be doing is I'm going to be throwing out some keywords here throughout the whole presentation, and you will need to send me those keywords at the end when you send me your email with all of your information for the credits. Then just put that information in there, all those keywords. There's going to be 4 keywords. We'll do 4 keywords, 2 per hour. And so just watch for those keywords or listen for those, and then we'll continue to proceed. Do anyone have any questions? We're good? Okay, let's move forward with this class. Mike, I'll turn it over to you.
Thanks, Stacey. Thanks, Yvonne, for having us today. We really appreciate the opportunity. This is a newer format for us and for well, I guess everybody's getting used to it by now, but I've been teaching CE classes for more years than I would care to count. And normally in a group setting, I love that type of situation where everybody participates, where everybody can interject with questions and comments, where we can share some laughs, even when we're talking about topics like foreclosure or bankruptcy. And so this is a little bit new, and but laugh to yourself. And y'all look great. Thanks for being here. One thing that's humored me a little bit during these times is when you'll watch the news or a program, and these celebrities or musicians that are normally very made up and prime looking will participate, and they look like the rest of us all of a sudden from their homes from afar. So from wherever you're joining, welcome, and we'll jump into this class today. As was mentioned, please, even though we're in this format, interject with questions, with comments, if you will, with war stories if you want to share them. Usually when I teach classes, I believe that less of me and more of you is better. So I'm going to continue to adhere to that policy if I possibly can. And so please feel free to speak up. And I know we have a number, connected remotely, but we'll do our very best to entertain those comments, those questions, those war stories. Interestingly, it's been, I don't teach this class nearly as much as I did, for instance, back in 2009, 2010. But I have a few times over the past year, and some of the initial requests that I'm getting post COVID outbreak are to teach this class, this bankruptcy class. And I hope that's not indicative of where we're headed. Perhaps it's on the minds of brokers and real estate professionals in terms of dealing with your clients, or potentially having to deal with clients in this situation, whether it's from representing a seller who's in bankruptcy or on the edge of bankruptcy, or representing a buyer who is trying to purchase from a seller who's in that situation. And even once in a while, we'll have buyers that are just out of bankruptcy or even in bankruptcy purchasing property as well. So we're going to address this from those different scenarios. And again, knock on wood, hopefully we're not headed that direction. Our market seems to be still very strong. Financing's very strong right now, but who knows what the next few months will bring, and we understand that, and we'll deal with that. But even in a healthy market, quite regularly I'm assisting our escrow officers who are very experienced, excellent escrow officers like Stacey. And we're dealing with a situation where we have a closing going on where there's a bankruptcy umbrella that we're closing under the shadow of that bankruptcy. And so we have regular communication within our company about these types of transactions, and we have a lot of experience dealing with them. And hopefully we can be that resource to you to assist you and your clients as they navigate these troubled waters. But as I suggested, perhaps we'll see more of these in the upcoming months or year or so, and we'll find ourselves in those waters even more frequently. But just so you know, transactions close regularly and commonly, even in a good market where there's a bankruptcy shadow, where we're closing within the framework of that bankruptcy. So that intro aside, and again, a request for questions, comments, war stories you'd like to share, just go ahead and interrupt at any time, and we'll jump into this right now. I know my presentation's frozen up for some reason.
Technology, right?
Yeah, I don't know why.
If you don't have your video on, please make sure you turn your videos on, because that's how we're giving you credit, is to visually see you.
I got to figure this out. Just a sec. Sorry.
You bet. In the meantime, can everyone hear him okay and see everything? And did everyone now have my email address?
Can you see all of their video faces now, Stacey?
I'm sorry, what?
Can you see everyone's faces now?
Yeah, I can. I don't see Nick or Karen.
So
let's see here. Okay.
While they're looking and checking things out, did everybody have an easy time being on? Oh, Nick Charles says he doesn't see. We are up to 19, so we still have 11 more that can get on. I'm going to mute because it looks like he's got his presentation going.
Okay, Amber just joined us.
Back on this. Now trying.
Is that working? Can everybody see that now?
Yeah.
Are we working? Oh, am I muted? Am I okay?
Yeah.
Okay,
Yep,
I saw
you're
your
good.
thumbs up. Great. So my first question as we start this out is, whenever I put together a CE class, I always try and put myself in the shoes of you as real estate, in your shoes as real estate professionals and brokers, and say, why is this topic matter pertinent to me? Why does it matter to me professionally, other than getting 2 hours of core CE credit? And here's what I think with respect to this issue, and that is this. Utah historically is among the national leaders in terms of bankruptcy filings, and that's not necessarily a good spot to be in. Most years over my career, we've been as a state in the top 10 pretty regularly, and definitely in the top 15. So we have a high bankruptcy filing rate based on our per capita population here in Utah. Just last year, there were approximately 9,000 total filings in Utah. And it's interesting to note, in looking at this, that as a state, as a populace, we had the third highest credit card debt in the nation at $11,000 per person. So I've been asked before, why is it that Utah has a higher bankruptcy filing rate? And I think that's probably answer number one there, is just we have a very, very large credit card debt ratio based on our population. And that's a pretty hefty number right there at $11,000 per person. Also, I think that there are a number of single income families in the state. And I think sometimes that leads to bankruptcy filing rate too. If one spouse loses a job and the other isn't working, that can factor into this as well. And I'm not saying that's good or bad. Those are personal decisions. But for whatever reason, and I think these are partially part of the reasons, is we have a high bankruptcy filing rate here in Utah. And again, that was the case last year, in that we came in at number 10 nationally in bankruptcy filing rate. That's better, 2 spots better than we were in 2018. We were number 8 in 2018. So we improved a little bit, but still holding down one of those top 10 spots that we've done traditionally. Just out of curiosity, how does Utah compare to other states? Sometimes I get asked that question. And here is the filing rate last year for the top 5 bankruptcy states here in the country, those who finished in the top 5. And again, this is not a good ranking to be in, right? But these are per capita filings per 1,000 residents. Number 5 was Illinois. Number 4, Mississippi. For whatever reason, the southeastern states have been hit hard the past few years in terms of bankruptcy filings. And interestingly, also, at least I found, is these totals, these top 5 were the same as they were in 2018. Georgia was number 3. Number 2 was Tennessee, and holding down the top spot in 2019, again, as they were in 2018, because they'd have never second place, the great state of Alabama. And again, they're celebrating that. That's supposed to be funny. I hope some of you are at least smiling. Alabama was number 1 again in terms of bankruptcy filings last year, as well as in 2018. Lowest bankruptcy filing rate. Usually I like to ask this question of the group. I don't know if anybody could check in with guesses, and we might have a winner. Does anybody want to proffer a guess, or does anybody know what the lowest filing rate was? Anybody entering the info?
I don't see anyone entering.
Someone said Montana.
Montana?
Good guess. It was the great state of Alaska. Once again, in 2019, had the lowest bankruptcy rate. Not sure why, but props to them. Maybe it had something to do with the oil industry, and maybe that'll change this year, given what's going on with that business right now. And tourism, double whammy potentially for that state. But it's Alaska again, and it's been that way for a couple of years. Just by way of bankruptcy background, I like to get into this as we start the class and just establish some common footing amongst us as far as understanding goes. And if some of this is a little elementary to some of you, I apologize. But again, I want to make sure we're all just on the same page as we start out. First of all, bankruptcies are covered for the most part by federal law. This is an area of commerce where Congress has decided it's a matter of interstate commerce. So as a result, the regulation and laws with respect to bankruptcy should be federal laws. And as a result, bankruptcy cases are heard in federal bankruptcy court. There's a shot of the federal courts in downtown Salt Lake City. The bankruptcy court is actually in that building just to the east, just behind everybody's favorite architectural building in Salt Lake, the federal courts. The bankruptcy courts are in the old federal courthouse, which is just located to the back right of that picture. To qualify for bankruptcy, the determination of eligibility is somewhat complex. It takes into account the petitioner's gross income, disposable income, the amount of debt, the type of debt, and the assets owned by the petitioner to determine whether or not they qualify for bankruptcy based on the federal law specifications. But just a quick summary of that qualification is this, my pyramid. And the situation has to be, the financial situation of the debtor has to be such that the assets and income of that individual or entity are such that there's no reasonable expectation that they'll ever be sufficient enough to cover and pay off the individual's or entity's debts or obligations. So in other words, they just have to be upside down financially, again, based on that formula, and then they qualify for bankruptcy. There are three types of bankruptcies that we deal with respect to our real estate transactions and closing them as a title company. There are other types of bankruptcies, such as a Chapter 12 farm-only bankruptcy, but I'm going to talk about a Chapter 7, 13, and 11 here today because those are 100% of the bankruptcies that we deal with. A Chapter 7 bankruptcy is available to individuals, married couples filing jointly, and also business entities. And by entities, I mean partnerships, limited liability companies, corporations, and such. It's commonly referred to as a liquidation bankruptcy, and here's why. What happens is a snapshot is taken of the debtor's financial picture as of the date the petition for bankruptcy is filed. And in that snapshot, the law allows the debtor to retain a certain dollar value of assets. And that can be equity in a home. It can be money in a savings account, a checkings account, vehicles owned, or whatever. But anything above that exempt amount are liquidated or sold off by the trustee to pay creditors. In Utah, that exempt amount that a debtor is entitled to retain, that value is, and this just changed in 2019, by the way, as I've noted there, and because historically for a long time, it was $30,000 for an individual and $60,000 for a married couple filing jointly. But just in May of last year, it changed so that the exemption went up to $42,000 per individual. And, oh, that's my math's bad there. It should be $84,000 as a married couple filing jointly. So again, a snapshot is taken in a Chapter 7 bankruptcy of the financial situation or status of the individual debtor or the entity debtor. And then anything above that exempt amount is utilized to pay off creditors. And that's done by a trustee. So a lot of times I get questions from agents saying, hey, can my debtors hold on to their home through this bankruptcy? And the simple answer is, if there's no equity in their home and the sum total of their assets don't exceed $84,000 if it's a married couple joint ownership, or $42,000 if it's an individual, then yes, typically they'll be able to hold on to that home if they choose to. But any equity beyond that amount, and that's a challenge we've had in the last few years. Challenge with respect to bankruptcy, not a challenge with respect to appreciation of the real property asset. But the challenge as far as a bankruptcy goes is equity has been accumulating at such a rate and at such a significant percentage, as you well know, over the past few years, that sometimes folks find themselves in a situation where, for whatever reason, they have to file a petition for bankruptcy. They have equity in their home that exceeds the exempt amount. And so as a result, they're either forced to come up with that money to pay to the trustee to satisfy creditors' claims, or if they don't have other resources where they can do that, they face the inevitable challenge of having to sell that home. But again, that's a marketing opportunity for you. Any questions about any of that at this point? Again, please feel free to interject. Also, in a Chapter 7 bankruptcy, the case is overseen by a bankruptcy court appointed trustee who, as I mentioned, sells those non-exempt assets that the debtor has. And those are paid off and used to satisfy the creditor's claims. Because these are a liquidation type bankruptcy, typically they're shorter in duration than a Chapter 11 or a Chapter 13 bankruptcy, and typically they're started and finished within 4 to 6 months, but they can go on beyond that time period as well. Once the assets of the debtor are liquidated, the non-exempt assets and the creditors are paid off to the fullest extent possible, the debtor's remaining debts are discharged and the debtor is given a fresh start. And so the balance of those debts are discharged, and again, the law allows for that fresh start. Any questions about a Chapter 7 bankruptcy? All right, just sometimes I get this question, how often can somebody go in and out of bankruptcy? And it depends on the type of bankruptcy. But if the debtor's been in and out of a Chapter 7 bankruptcy, then they can't file a subsequent Chapter 7 bankruptcy and get a discharge until 8 years after that previously filed Chapter 7 bankruptcy, or with 8 years if it's Chapter 13 bankruptcy. So there's the possibility, of course, of them going back into a bankruptcy at a later date. But the law has changed significantly a few years back to make that less available to debtors who have been previously in bankruptcy, or makes the time period before they can file again longer. The Chapter 13 bankruptcy, a little different than a Chapter 7. This is available to individuals with steady income and have a secured debt less than approximately $1.2 million. And unsecured debt less than approximately $400,000. So if you have a secured debt beyond that amount, an unsecured debt above that amount, then you can't file for a Chapter 13. You'd have to file for a 7 or a Chapter 11, which I'll get to in a moment. In contrast to a Chapter 7 liquidation bankruptcy, a Chapter 13 bankruptcy, it's commonly referred to as a reorganization bankruptcy, because here's what happens. At one point during the bankruptcy, a formal plan of reorganization is filed by the debtor with the bankruptcy court. Creditors have the opportunity to object to that plan if they don't like it, but ultimately the judge in the bankruptcy decides whether or not the plan will be accepted. If it's accepted, then that is the plan that the debtor is required to follow, and that reorganization plan is overseen by a court-appointed trustee.
Hey, Mike, we have a question.
Please.
Yeah, we have a question.
So we have Amber McIntyre. She has a question. She just said that she missed, what's the difference between secured and unsecured?
Yeah, great question. Yeah, great. Thank you for that. Secure debt is one that has collateral to secure the debt. In other words, if the debtor is unable to pay the debt, then the creditor has the ability to foreclose on that collateral. And typically that comes in the form of something we're very used to in our business, in real estate and title. And that is, it's a lien on a home. Some secure liens are created voluntarily, such as a deed of trust, a mortgage. At the time that the home is purchased or when a second mortgage is taken out, the homeowner will sign a promissory note promising to pay that loan back together with interest over a period of time. But to secure that debt, to secure that obligation, the borrower voluntarily gives a security interest in the form of, we call them mortgages here, but they're really deeds of trust on the home, and that's recorded in the county recorder's office and gives that lender, that creditor, that security interest, so that in the event that the borrower homeowner fails to perform his or her obligations under that note, then the creditor, the lender, has the ability to go in and foreclose on that mortgage. Some secure debts are involuntary, such as a tax lien. Somebody fails to pay their state or federal taxes or both, then the IRS or the state tax commission could come in and record a lien against any assets owned by that debtor. For our purposes, it would be a real property asset, a home or a cabin or a condominium or whatever, investment property, whatever. And so that creates a security interest. Another type of secured lien is a mechanic's lien. If the homeowner arranges for a contractor to supply labor or materials towards improvement of that real property, of that home, and then payment is not made, the law gives the right to that contractor or subcontractor to record a lien against the property, and then that becomes a secured lien, because like a tax lien, that mechanic's lien can be foreclosed as well. That the property can be sold to collect payment under that obligation. Another common form of lien is a judgment lien, where the property owner will get a judgment against them in court. It could be child support, it could be alimony, it could be a breach of contract claim, it could be whatever. And once that judgment is entered by a court, and if it's recorded in the county recorder's office, and that becomes a secured lien on that property as well, that can also be foreclosed to try and collect that debt. So those are secured liens. Unsecured liens are liens, for instance, most commonly for credit card debt, where you're borrowing on a credit card. The finance company advances those purchases, and then that debtor fails to perform under the obligations of the credit card, then that's an unsecured debt, because the finance company, the credit card company, doesn't have any collateral and assets owned by that debtor to foreclose on. So that's an unsecured lien, most commonly, credit card debt. Did that answer the question okay? I hope that did.
Also, if you can
Please.
hear me, the key word is reorganization.
So hopefully that answered the question okay. If not, please give us a thumbs down.
Hey, also, one thing, sorry, Mike, to interrupt you, but I just want to let you know what you're supposed to do if you've joined us late is that when you send me your license and your phone number and your email, you're going to send me the 4 keywords at the very end.
And don't ask me, because I cannot tell.
Okay, the last one that we did this, they gave us a link and we put it into a Google Doc, so that's why I was checking. But I tried really hard to get on time. I couldn't get the link to work. So, so just to send you an email. Do you have an email?
Yeah, so when you send me your email, it's in the chat. If you just scroll down through the chat.
If I'm new, I don't have old chat. So can you put it in there
okay. Let me just resend it to you right now. It's no problem.
Sorry, I'll stop interrupting.
Okay, sorry, Mike. Go ahead.
No, good. Thank you. So hopefully that answered that question. Back to our Chapter 13 bankruptcy. This plan, again, is supposed to be followed by the debtor. It's overseen by the trustee. And what happens in a plan of reorganization is debts and obligations of that debtor can be reorganized. The financial picture can be restructured. In other words, if the debtor is faced with a high interest, short amortized type obligation or debt, such as a promissory note, that can be modified during the plan of reorganization to make it repayable on terms that are more palpable for that debtor. And that's what goes on in this plan of reorganization. If the debtor fails to follow the plan, then typically the Chapter 13 case is converted to Chapter 7 case, excuse me, and then the assets are quickly liquidated at that point. Because these plans typically go out longer in time and have a longer duration than a Chapter 7 bankruptcy liquidation, Typically, a Chapter 13 will be 3 to 5 years in duration from beginning of the bankruptcy till the conclusion and the paying off of the plan of reorganization and then the discharge. But once the plan is completed and the bankruptcy is paid off, the debtor's remaining debts are discharged, and like in a Chapter 7 bankruptcy, that debtor is given a fresh start going forward. If a debtor has been in and out of a Chapter 13, you can't get into a 7 bankruptcy for a period of 4 years thereafter, or another Chapter 13 bankruptcy for another 2 years. But as you can deduce there, you can be in and out of a Chapter 13 bankruptcy only to return to it 2 years later, and that is permitted by the law. Chapter 11 bankruptcy, just quickly on that. This is available to business entities or individuals, and business entities cannot file a 13. And then these are for individuals who have secured and unsecured debt in amounts that exceed those limitations specified for a Chapter 13. So as a result, they're pushed into a Chapter 11 bankruptcy. And just by and large, these are very similar to Chapter 13 bankruptcy, but they're on a larger scale. A plan of reorganization is filed, and usually we see businesses, these business entities that are in 11s, although sometimes we do see individuals there as well. But because of the nature of the size of the bankruptcy, the assets involved, the debts involved, these Chapter 11 bankruptcies can be long in duration. And I even saw one once some years ago when I was working at a law firm. We were involved in an outside bankruptcy situation with a large local company that went on for 9 years. So they can go on for a significant period of time. Any questions about the types of bankruptcies? Jump in if you have any, and if not, we'll keep moving. All right, just logistically, how does one file for bankruptcy? We used to have to go down to the federal courthouse and the bankruptcy, where the bankruptcy courts are located, and make the actual filing. Now, as we know today, case in point, what we're doing right now, this is all done electronically. And so somebody even in a remote spot in Utah can file a bankruptcy petition in the federal courts located here in Salt Lake remotely. As I mentioned earlier, federal law applies for the most part. These cases are filed in federal bankruptcy court, and in general, that federal law applies, although there are state laws that apply related to some issues, such as qualification for bankruptcy and exemption. For qualification purposes, that formula takes into account median gross income here in the state. And so the federal law defers to the state in terms of determining a qualification. And also, as I just alluded to, the exemptions are determined by state law as well. And as I mentioned, here in Utah, it's $42,000 per individual and $84,000 for a married couple filing a petition for bankruptcy jointly. So most bankruptcy cases are started by the debtor voluntarily filing a petition with the bankruptcy court. There are some cases, however, that are filed involuntarily by a creditor, and these usually involve a business that has income and assets that could be used to pay the debt. So, in other words, if a creditor is selectively choosing who the creditor chooses to pay to the exclusion or detriment of other creditors who should be on equal footing under the law, then those creditors, or even a single creditor, can push that debtor into bankruptcy involuntarily. So the law will apply, a trustee will become involved, and the distribution of those income and assets will be overseen by the trustee. So the preferential treatment by the debtor goes away in that involuntarily incurred bankruptcy. The debtor is required to list as part of the debtor's assets all assets, income, liabilities, and creditors. You can't try and hide things this way without being uncovered. So it's an obligation on the debtor to list all those assets, income, liabilities, and creditors. The petition is then reviewed, and a determination is made whether under the legal standard the debtor qualifies for bankruptcy. If the debtor does not qualify, the case is dismissed. Basically, the debtor is thrown out of the bankruptcy. and is no longer in bankruptcy, and that filing has no effect on the title to the real property owned by the debtor or the closing of the transaction involving real property owned by that debtor. So as a title company, if we see that a property owner has filed for bankruptcy, but the bankruptcy's been dismissed, then we will just show that we won't even show that bankruptcy on a title insurance commitment on that PR. However, understand that even though a bankruptcy is dismissed, it can still cause some serious credit issues. At least so I'm told by my lender friends. So even filing a petition for bankruptcy that's dismissed, that will cause some credit hits. Any question about that? All right, moving along. We're setting a record for fewest questions asked ever in a CE class. That's okay though. I'm just used to more questions, but I understand our situation. With all that in mind, sometimes we hear these famous last words, and usually those words are repeated from real estate agents quoting their clients. And they'll say, we didn't include our house in the bankruptcy. So what happens is they'll list their property for sale, a commitment for title insurance, that PR will be distributed back to the seller and the listing agent. And noted on that title insurance commitment back on Schedule B, Section 2 will be an exception for a pending bankruptcy because we search the bankruptcy court records to see if any of the parties involved in the transaction are currently in a bankruptcy. And these are the famous last words that sometimes come back. They say, we didn't include our house in the bankruptcy. And the point is that they're trying to make is we didn't list that as an asset. Therefore, in our minds, we should be able to sell this house no problem without any bankruptcy court or bankruptcy trustee involvement. Well, the response to that is they have to include any asset in the bankruptcy, whether they do that intentionally or even without having a clue. They have to include those assets in the bankruptcy. And once in a while, we'll see this. And the failure to do so, the terminology is kind of harsh describing it, but it's known legally as committing fraud on the court. So if they have an asset and they don't list it, they need to go back and amend their petition to add that asset. So if you have a client telling you, yeah, we're in bankruptcy, but we didn't list the house in the bankruptcy, understand that they have to do that. They're legally required to. Sometimes they'll say the house is not included in the bankruptcy or not involved in the bankruptcy, and that may mean, as I'll talk about here in a minute, that the trustee has already scrubbed through that asset and made a determination that it brings no value to the bankruptcy estate above the exempt amounts that we discussed previously. And so correspondingly, and as a result, the trustee will abandon that house out of the bankruptcy. In other words, give the asset back to the debtor, and then they are free to do with it whatever they want to without any control by the trustee or the bankruptcy court because it's been abandoned out of the bankruptcy estate or handed back to the trustee. So if that's what they mean, we get that. But just failing to list the house as an asset in a bankruptcy, they can't and don't get away with that. When the petition for bankruptcy is filed, this legal protection automatically kicks in, and it's called an automatic stay, and it becomes effective immediately as of the time that the petition is filed. And when that automatic stay is in place, the creditors of the debtor are prevented from pursuing legal actions that they normally would be able to pursue if the debtor were not in bankruptcy. So they're stopped. It's a stay. They're stopped from pursuing any collection actions against that debtor while the stay is in place. So examples of those type of actions are debt collection actions, the commencement or continuation of lawsuits against that individual, the commencement or continuation of foreclosing proceedings. Those are stopped or barred from happening at the time. And even short sale negotiations. Those who remember 2009, 2010 will remember we were negotiating a lot of short sales back then. And if you had a situation where you were working with a client trying to sell a house and you were having short sale negotiation with that client's lender, and subsequently that client filed for bankruptcy, then once the lender was notified of the pendency of that bankruptcy, they could not have further negotiations or discussions about restructuring loan, about a short sale payoff, that type of thing, that's stopped while the automatic stay is in place. And that automatic stay is in place for the duration of the bankruptcy or until the court grants what's called an order giving relief of the automatic stay. And that's obtained by a creditor who makes a motion to the bankruptcy court saying, hey, look, here's our situation. We should be able to collect or seek to collect this debt against this debtor now in bankruptcy. And if the court agrees, the court will give relief to that creditor pursuant to that motion. And issue an order granting relief of the automatic stay. That most commonly takes place with respect to foreclosure proceedings, either the creditor, the secured creditor, the bank having a desire to start a foreclosure against that debtor who's behind on mortgage payments, or to continue a foreclosure that had already been started at the time the debtor filed for bankruptcy, and then it allows them to ramp up that foreclosure again. Any questions about that? And I just addressed this. The creditor can make that motion to the court for an order granting relief of the automatic stay. What else happens when a property owner files for bankruptcy? And I'm going to bring this into how it relates to us and our transactions. As we've discussed, the assets of the debtor really are no longer the assets of the debtor. Instead, they become assets of a bankruptcy estate that is no longer managed by that debtor, but overseen by a court-appointed bankruptcy trustee. And sometimes that's really, really hard for debtors to get their head around that. They're used to managing their own assets, good or bad. And all of a sudden, you've got a court-appointed trustee who comes in and really has oversight over the distribution and management of those assets. So as a result, that debtor can't enter into material financial transactions such as selling a home without requisite court or trustee approval. So any material contracts that debtor can no longer enter into without the court or trustee approval. And again, that's sometimes hard for them to get their head around. But obviously, as you are anticipating, I believe, and as we'll get into specifically here in a minute, I don't know. I haven't been in the 7-Eleven lately. You can go to the store. That was pre-COVID-19. They don't have masks on or gloves. But you can go to the store and buy your normal goods. But you can't list a house for sale. You can't enter into a contract with a brokerage to list the home and enter into a real estate purchase contract to sell a home to a third-party buyer. So to do that, and that specifically affects us, those property listing agreements, REPSIs, we've got to have either court or trustee approval. And I'll talk about specifically what that is and describe it in detail here in a minute. But just to understand generally, if you've got a client and they're in bankruptcy trying to sell their home, they can't do that without trustee or court involvement. Similarly, if you have a client and you're their listing agent and they file for bankruptcy during the course of your listing, that changes the playing field as well. And we're going to have trustee or bankruptcy court approval of that process as well. And I'll get to that here in a minute. Here's a challenge, and it's something that's potentially an obstacle to all of us. Any material contracts that the debtor is a party to at the time the bankruptcy is filed, such as listing agreements and real estate purchase contracts, those can be accepted or rejected by a trustee after the fact. So understand, if you have that client who's having financial challenges and believes that they need to sell the home, and you've entered into a listing contract, or even they've entered into a real estate purchase contract with a buyer, and then at that time they take out bankruptcy, understand that the trustee can come in and disallow those contracts. They can reject, literally that's what it's called, they can reject that REPSI, they can reject that listing agreement. if they choose to do so, if they find out that it's not financially advantageous to the debtor and correspondingly the creditors that that debtor to sell the home at that time, then they can reject those contracts. So that can turn the card over on your listing arrangements. So what do you do in those situations? And again, they do come up. Here are just some practical pointers that I have related to what I have observed over the years. First of all, don't go run and hide in the corner and feel that all is lost and all the effort and time and energy and money that you spent marketing that property is lost. Same with that. Don't give up.
Hey, Mike.
Yes, please.
Looks like we have a couple questions on here.
Awesome,
Donna Lee, she said, how often does that happen?
Does the bankruptcy trustee reject contracts? I think that was the question.
Yes.
Very, very rarely.
Okay.
Very rarely. If it's a fair arrangement, if it's a third party purchaser for value and not somebody's uncle trying to buy the house, not the debtor's uncle, trying to buy the house at a 60%, to fair market ratio, then rarely will a trustee come in and reject those contracts. So that's the very point. Don't go hide in the corner, hang in there, and I'll give you some practical pointers as to how to do that. But it happens rarely. If it's a third party purchaser for value, it's a fair market offer, then the trustee will typically not touch that.
And then Amy wanted to clarify, if a client doesn't tell you they have been through a bankruptcy, when would it show up?
It'll show up on the PR.
Yeah, if they're currently in bankruptcy, and sometimes, it's somebody your kids go to school together, it's somebody down the street, you go to church together or whatever, and they don't want anybody to know their financial situation. Sometimes we get it, they'll withhold that kind of information. But as Stacey points out, once a title search is done, we check the bankruptcy court records, and if they're in bankruptcy, that will show up on Schedule B, Section 2 of the title insurance commitment.
Yes.
So, and here's this point. If you're that listing agent and your client is not yet in bankruptcy, but they're experiencing financial difficulties, they've just lost the job for whatever reason, they're unable to make their mortgage payments for whatever reason, they just got divorced. Ask that client to keep you apprised of any material decisions that they make that might affect the listing. And you can do that, obviously, much better, I'm sure, than I could, more diplomatically than I could. But if you know that they're in in difficult financial straits, just say, hey, if you make a decision related to your financial situation during the course of listing, give me a heads up. And hopefully they will, and they'll tell you if they file. Sometimes, again, for the same reasons, though, they won't. And hopefully that doesn't become a surprise to you. But as Stacey mentioned, either at an initial title insurance commitment or even during after that commitment's been issued, if they subsequently file for bankruptcy, we can do an update if you want us to check and see on that update to see if anything's happened since, such as if there's been a notice of default entered that would start a foreclosure or that they filed a petition for bankruptcy.
I just wanted to mention too, that's one of the things that we take pride in is when we go under contract or we see a contract come through, we, as U.S. Title, reach out to the seller and we ask some of those challenging questions that may be a little bit sensitive for you to ask. We go through a list of questions that we ask them, and we also let them know if there's any of these scenarios that change throughout your listing or the transaction, please make sure that you keep us abreast of those so that we can address those challenges and make sure that everyone is aware of what we need to do in order to fulfill those requirements.
Thanks, Stacey. And again, I mentioned this last point a few minutes ago. If your client files for bankruptcy during the course of that listing, just keep proceeding with your work. I'll give you some practical pointers that might help you as you go forward. But all is probably not lost. Assume your listing agreement or even a real estate purchase contract that's in place won't be rejected by the trustee. And again, great question that was asked earlier. When does that happen? And it's pretty rare. And it just has to be a situation where it's not a fair market transaction to that seller. So proceed ahead.
Two things really quick, Mike. I'm
Yes,
just going to mention, once again, the first keyword was reorganization, and the next keyword is involuntary. Reorganization and involuntary.
Thank you. We're required to give those out by our regulators and your regulators, I think, just to make sure everybody's involved. So thank you. Another just practical pointer here, just hopefully that's helpful, just derived from my years of being involved, observing these and closing these transactions. If you're that listing agent and your client takes out bankruptcy during the course of your listing, communicate with that client, even if they are somebody who's a close personal friend, a neighbor, whatever. Obviously, you let them know that whatever they tell you will be kept confidential, but they need to communicate with you, and hopefully they will. Communicate with their bankruptcy lawyer, and hopefully he or she will communicate with you. And I'm going to get to that in a moment. And perhaps as an agent, you'll even have some communication with that trustee, which is okay as well. And most of these trustees are overworked and pretty ornery, but they all have communication with real estate agents like yourselves on occasion. So that's another source that you may have to go to as part of this process. If the property is under contract, obviously as a listing agent, have the courtesy to inform that buyer's agent, the selling agent, that your client has filed a petition for bankruptcy. Obviously, if you were in the shoes of that buyer's agent, you would want to know as well. And again, we can find that information out by doing a title search, but as soon as that happens, hopefully real estate professionals have the courtesy one to another that they'll keep each other apprised of what's going on, because that buyer, that impacts the contract, perhaps the ability of the seller to sell the property, definitely affects timing of the sale. So you want that buyer to receive full disclosure and be able to make decisions accordingly.
Hey, Mike.
Yes, please.
Patty asked, how are the trustees paid?
Great question. They receive like a basic fee, but much the bulk of their compensation comes from, they get a percentage of the value of the assets that they recover for the bankruptcy estate. So it's a set percentage, and if somebody has to sell their home because there's $100,000 of equity in it, they'll get a percentage of that value realized for the bankruptcy estate. The challenge associated with that is they're typically very aggressive, because the more they recover, the more value they can maximize, the more they make as part of their job. So don't assume that these are nice people who want to be your client's friends necessarily. Most of them are good, they're reasonable, they're fair. But that's their job, is to maximize value for creditors, and correspondingly, I think they have a selfish interest involved in that. A significant portion of what they make is derived from what they pull in out of the estate. Hopefully that answered the question. It didn't depress anybody today. So, all right. Again, if you're the selling agent representing that buyer and the seller files for bankruptcy, be persistent with the listing agent to get information in order to advise your client properly. And here's what I've seen over the years. We have agents of different skill levels and experience. And sometimes agents haven't dealt with these much, and that's okay. Good agents still figure them out, and they ask questions, and they consult with trusted advisors. But some don't. And as an agent representing a buyer where you have a seller that files for bankruptcy during the course of the listing, or even is in bankruptcy up front at the start of the listing, don't assume that listing agent will keep you informed. I just made a plea to please do that to each other. But don't assume the listing agent's going to do that or even understands the process. So just stay persistent, asking questions about listing agent filing out the status of the bankruptcy, of any court or trustee approval that's needed for the sale. It's okay to ask those questions. And again, a plea to the listing agents, have that communication with the buyer's agent. Don't leave them in the dark. real important point here, just a practical pointer, I hope, and that is, as a listing agent, communicate with your client's bankruptcy attorney. Hopefully they're your friend. You represent a common client. And I've told bankruptcy attorneys, the value that the real estate agents provide to that common client in trying to get property sold that either needs to be sold or they've chosen to sell in that bankruptcy. And so communicate with that attorney, and that attorney should respect you and answer your calls and answer your emails and respond to you.
We have another question, Mike.
Please, thank you.
Donnelly asks, is there a way we can find out if it's a possible issue?
I'm not sure I understood that one.
You can elaborate, Donnelly, if you go ahead.
Please.
So you were talking about sometimes if we're the buyer's agent, we may not get communication from the seller's agent that there is a bankruptcy in process or that it's an issue. My question is there a way that we can go about asking tactfully, or, if this becomes more of an issue in the future, is there a way for us to find out ahead of time to kind of protect our buyer from going into a more tricky situation like that?
Yeah, I wish I had a good answer for that. I just wish that the listing agents would respect the situation you're in and your buyer's in correspondingly, and have that communication. I mentioned in passing, Donna Lee, that if you're concerned for whatever reason as that buyer's agent, you can ask the title company you're working with to do a date down, or we call them date downs, but they're really updates of a title insurance commitment. And that'll show if the seller is in bankruptcy. That'll show if a notice of default's been recorded. If you're
sorry, I missed that. Thank you.
And so I would just, that's one third party that you can go to. But again, part of the frustration I've seen with good agents over the years representing buyers in these situations is the listing agent, it just doesn't understand the process or doesn't want you to know much. If they're telling you something and I'm going to get to that point in a minute, I'll make it now though. If they're telling you something that just is not adding up for you, then ask trusted advisors, ask coworkers, good agents who have perhaps have more experience in working in this venue. Call us up, ask us up, call me up. I'd be happy to tell you, what they're telling you is not adding up for me. I don't think that's accurate. Ask, and then I would reply to you saying, ask these type of questions to hopefully generate a better response or more information coming from that side. So I just mentioned here's a problem with your common client's lawyer is sometimes they're not cooperative or communicative. And that can be extremely frustrating to you as that listing agent trying to list and sell a home for that common client. And they should be, and I've had conversation with bankruptcy lawyers before about that I really think that they should be, and they need to understand the role that you play in this process. And as I just mentioned, if you're getting information you don't believe is accurate, or if you're running into a stone wall, consult with trusted, experienced advisors who can give you advice on the side and perhaps point out some practical pointers that will assist in getting more communication or getting more cooperation from the lawyer. And as I just mentioned in response to Donna Lee's question, real important is make sure that you get and review a commitment for title insurance. If a party to the transaction is in bankruptcy, it'll be listed as an exception on that commitment. And then an update to that commitment, to the original commitment, will show any subsequently filed bankruptcies that have happened since the date of the original title insurance commitment. And again, as a title company, we're happy to provide these in connection with transactions that we're involved with all the time. Real fatal potential obstacle to your closing here and your role in this process, and that is this. Just something I've seen and learned from over the years, and that is if you have a seller client who's in bankruptcy and loses motivation to close the transaction, In other words, they don't care if the property's sold or if it's foreclosed. You know, their bankruptcy lawyer may be telling them, hey, you're not going to get any value out of this property, whether or not it sells or whether or not it's foreclosed, if it's in a foreclosure situation. And that bankruptcy lawyer may be chirping in their ear, just saying, hey, none of this matters. You know, quit trying to sell this property. Just let the lender get relief of the automatic stay and foreclose if that's what the lender's trying to do. If your seller at any point loses motivation to close the transaction, then that's when I advise you to pack up your tent and walk away, because that always proves fatal to the sale of the property owned by that seller debtor out of the bankruptcy. Eventually it'll get sold, but it may be through a foreclosure sale. It may be subsequently by a trustee and they want to use their own agent. But in the meantime, the transaction just stalls. The status of the property is stalled, sometimes indefinitely. And if you find yourself in that situation, don't spend any more time and money and effort trying to market and sell that property. That's my advice. So if you have an unmotivated client, walk away. Sometimes there just isn't any motivation. If that's your guy, just walk away from that transaction. It's supposed to be funny. Sorry, but there you go. What might motivate a client, even in a situation where their attorney is telling them you're not going to get any money out of the sale of this property, whether it goes into foreclosure or whether or not you sell it? Here's just hopefully some practical tips that I have observed over the years that might motivate a seller. Some of them you'll probably smile at and think, really? And my answer is yes. Sometimes these folks just have pride in the property. They want to see it sold to a selected buyer that they choose instead of having it foreclosed on and possibly fall into a neglected condition. I can't count the number of times over the years where I've seen this as a driving, motivating factor to keep people involved in a sale, selling property, where they're in bankruptcy and where they're not going to get anything monetarily out of the sale. Just pride in the property may keep them in that. You know, they've raised their family there and they had a lab once upon a time, and now these buyers have young kids and they have a lab and they want to see the property go to them. You know, I've seen situations where somebody unfortunately is in financial distress, they're in bankruptcy, they have these beautiful gardens at their home and they don't want to see those fall into a neglected condition if the property goes into foreclosure. So they want to have a role in choosing that buyer. They don't want to see the water pipes freeze up and the deck or whatever destroyed. They just have pride in that property. And that can be a motivator in and of itself. Even more importantly, and perhaps more compelling though, is this motivation, and keep this in mind. A debtor who was previously in bankruptcy can't qualify for a conventional loan until 4 years after discharge in a Chapter 7 and 11 bankruptcy, and only 2 years after Chapter 13 discharge. Conversely, if the seller allows that property to go into foreclosure and it's foreclosed instead of sold, and foreclosures happen under the bankruptcy umbrella as well, that former property owner, that former debtor in bankruptcy can't qualify for conventional years until 7 years after that foreclosure. So that's a conventional loan. So if there's a bankruptcy plus a foreclosure, it compounds that credit hit. It extends it out, qualification out for 7 years instead of 4. So if that's a motivating factor to your seller, remind them of that. If their attorney's telling them it doesn't make any difference to you financially if this property's sold while you're in bankruptcy or if it's foreclosed, they could turn that around and say, yeah, it doesn't make any difference to me financially in terms of dollars in my pocket perhaps, but it makes a huge difference to me potentially of qualifying for a loan after the fact. And I think that's especially important and useful information to younger clients, younger sellers who just had a challenging financial situation come upon them. They have to file for bankruptcy, but they've got a long life ahead of them. They've got, you know, the ability to borrow more money down the road, and 2 or 4 years is a lot quicker than 7. So let that be a motivating factor as well, and hopefully that'll keep them motivated as you take that listing or as they file for a petition for bankruptcy during the course of the listing. Hopefully that'll be a motivation to them to hang in there and try and get the property sold. Any questions or comments about that? All right. So all morning so far, we've talked about the fact that, and I mentioned this very early on, that we're in a different playing field here as we deal with transactions that we're trying to close where a seller is in bankruptcy. And I mentioned early on that, you know, you can buy the big gulp, you can go to the grocery store, but you can't sell a property without some type of approval. And that approval is obtained one of two ways. And I want to talk about that in detail now. How does our client get that court approval or trustee approval so that they can sell the property? Because remember, this asset now is no longer theirs. It belongs to a bankruptcy estate legally that's managed by a trustee. Practical pointer number one here, and I've touched on this a couple of times before, and that is this, that a good bankruptcy attorney representing the seller or the debtor is often the key to success in getting the property sold out of bankruptcy. If they're useless, and I'm an attorney and I don't have a problem saying that because sometimes they can be that way, or they're not returning calls, they're not communicative, they're not helpful. I've even had agents ask me, can my seller client switch bankruptcy lawyers right now because theirs is not even responding? And I said, yes. Just like if you don't like a doctor you're seeing or you want another opinion or help from somebody else, you could switch physicians. You could switch bankruptcy lawyers as well. And that happens. So if you've got somebody who's frustrating your client and frustrating you, your client can switch to somebody who will be helpful and cooperative. I call these some bankruptcy attorneys, interestingly here in Utah, we have a high per capita bankruptcy filing rate, as I mentioned. We also have a high per capita attorney versus non-attorney rate here in Utah. And so we have a lot of attorneys and we have a lot of attorneys doing bankruptcy work. Some are very, very good, some not so much. They'll dabble in bankruptcies and I call them the photo mat of bankruptcy lawyers. And when I say photo mat to my kids, even my adult kids, they have no idea what I'm talking about. So I went and researched it once to see if I could find a picture of a photo mat. And I could only find the simulated photo. They're all gone, of course. For the younger generation listening in today, you know, when you used to take pictures, you used to have to go to the drugstore or the photo mat and get them developed, and they'd return your pictures to you after a couple of days when you drove up and got them. You drop off your film, you come back, and you get your pictures. You're probably looking at me like, what are you talking about? But this used to happen. I noticed, though, that they're being refurbished. That one's now a coffee stand. That one's a prayer booth. So they're still getting some use out there. But I equate some bankruptcy lawyers to being photo mat type lawyers where the client will roll up, pay them a fee to file the petition for bankruptcy, and that's about all they get. And you know, sometimes the fee's lower, but sometimes you get what you pay for, and that can be very, very frustrating to your clients and to you as well. So hopefully we have a good lawyer involved who's communicating with you and you're working together to try and get this property sold. That attorney should work with you to address the best interests of your common client, that seller. So back to bankruptcy court approval. Hopefully we have a good attorney at our side working as we try and get this. But here's the fundamental rule, and if you remember nothing else today, hopefully you'll remember this, and that is that the debtor can't sell real property owned by that debtor or acquire real property if by chance the debtor's in bankruptcy without formal legal approval. Some of us who are older too, when we were driving up and dropping off film to be developed at the photo mat, we were also outside playing games. I remind my children of that you know, we used to play outside and not always inside with video games. I'm just kidding. But we used to go out, we played these kind of foolish games, sometimes just silly made up games. One of them was a game called Mother May I, and it was just kind of this strange game that we played when we were kids where usually the toughest girl in the neighborhood was in charge. She was the mother. And you'd line up and ask these, you know, if you could take 5 steps forward or throw a 360 in the air or whatever. And then if he or she wanted to give you that opportunity, she would say yay or nay. And again, no wonder we evolved into playing video games, right? We got rid of these kind of games. But we used to do this. Well, I equate this to bankruptcy court approval. In other words, a participant cannot sell real property without that approval, without approval from the mother. And that comes in the form, one of two ways. So in general, that during the bankruptcy, that debtor, the debtor can't sell, acquire, or finance real property without the approval of the trustee or the bankruptcy court judge. So if we're in that situation trying to help a seller sell property, they're in bankruptcy, we cannot sell the property without the approval of the trustee or the bankruptcy court judge. The rules of sale, the rules of the transaction are completely different. So again, if you take nothing away from this class today other than that fundamental concept, understand that your seller cannot sell the property without trustee or bankruptcy court judge approval. I'm going to break down both of those right now and give you a lot of detail, probably more than you want to know as to the specifics of each one of those. First of all, getting approval for a transaction for a sale in a 7, 13, or 11 bankruptcy where the seller is involved in one of those bankruptcy. A debtor must obtain one of the following in order to sell or purchase the property. First of all, a trustee abandonment of the property or a court-ordered sale of the property. Let's look at trustee abandonment first. What happens in this situation is this: the trustee analyzes and assesses the non-exempt assets of the debtor in the bankruptcy estate. And assets that are worthless to the estate, meaning they bring no value beyond that exempt amount, the trustee will get rid of, and including real property assets, including the debtor's home. And what the trustee does that by filing what's called a notice of abandonment with the court. And then the notice of abandonment may be specific to property or maybe general as to the assets of the debtor. And that typically comes at the end of the bankruptcy where the trustee files what's called the no asset report. And even though the bankruptcy hasn't concluded yet, the trustees file the no asset report that basically says, I have examined all the assets of this debtor. Anything that's above the exempt amount has been liquidated or paid off as part of the Chapter 13 plan of reorganization. So I'm abandoning any other assets that remain in the bankruptcy estate. At that point in time, the debtor is free to sell the property. Now, this process is relatively informal and it's quick. And it usually is the course taken to get property sold out of the bankruptcy because of the fact it's informal and it's quick. I mentioned earlier that as a real estate agent, you may be having conversations with the trustee assigned to the bankruptcy of your client, that seller debtor. And this is one situation where you may have that conversation where you're bringing it to the attention of the trustee that the trustee has an asset here that has no value above an exempt amount. And, oh, by the way, will you file this notice of abandonment with the court? And they're typically responsive to that. And that's part of their job is to do that valuation of that asset. And again, these can be email communications, phone calls, and it's a relatively informal and quick process. As a result, most debtors in bankruptcy selling real property choose this route of approval, the trustee abandonment, as their preferred route. Here's the rub. The trustee will only abandon that asset out of the estate if there's no equity in the asset. But again, that's their job to figure out whether or not there's equity. If they're wrong, that's on them. That's not on your seller. So sometimes we'll see an abandonment of the asset. The seller can go ahead and sell it, and then they'll realize value beyond the exempt amount. And people say, ooh, stop, is that a problem? Well, if the trustee has undervaluated something, that's the trustee's problem. And the creditors have the right to object to that abandonment ahead of time as well. So once that asset is securely and safely abandoned back to the debtor, they're free to sell it. But again, the fundamental notion here is that the trustee will only abandon if there's little or no value to that asset, to the estate. But once it's abandoned, as the diagram there shows, the debtors are free to sell that property. It's no longer under the umbrella of that bankruptcy legally. It's no longer part of the bankruptcy estate. Here's something to keep in mind in these situations. The property is subject to the recorded liens, to those secured liens. So oftentimes when a trustee is willing to abandon the property, it's because it's fully leveraged or it's over leveraged by those secure liens. In other words, they exceed the value of the property. We saw this a lot back in 2008, 2009, 2010. And if it's abandoned, that doesn't release the liens from the property. It just means that the trustee has abandoned it out of the bankruptcy estate. So the debtor is now free to sell it. But what that does is puts the debtor seller back in the situation that they otherwise would have been in outside of the bankruptcy, where they're forced into, or to get the property sold, they have to engage in short sale negotiations with those lenders. And many of you had that experience. Hopefully we never go back there. But this was a common occurrence back in 2009, and we still see it from time to time where a property is abandoned by the trustee out of a bankruptcy estate, and the seller is left with the agent to try and negotiate a short sale with those secured lenders whose liens must be released voluntarily in order for the title to be transferred free of those liens to that third-party purchaser. Any questions about that? So again, this is the most common course that people take to get approval when they're trying to sell property and they're involved in a bankruptcy. Is this trustee abandonment? But as I mentioned, often that involves a subsequent short sale that must be negotiated with those secured lien holders of the property.
I have a question for you, and maybe you're going to be touching on this, but I just wanted to see, because this will be my next key word, is stripping the lien.
Yeah, I call it avoiding the lien, but stripping is much more colorful. So, and it's often called that. Yeah, thanks, Stacey. It is. Yep.
So keyword is stripping the lien.
Okay, perfect. I'm going to get there. Here we are.
Can I ask that? Is that stripping?
Yes, there's probably a better terminology Mike can use, but it's, and he may be able to mention that when he talks about it.
I'm going to call it avoiding, but I don't want that to be not the key word. If you want it to be stripping, that's great.
That's just how I've used the terminology, but stripping a lien.
So our second way of getting approval for a seller in bankruptcy to sell real property is this court-ordered sale. And again, the more common way is through trustee abandonment, but it's also accomplished this way through a court-ordered sale. And I'll tell you what might be the advantage to this here in a minute, but tuck this away. This is the second mother approval process. This is the judge. I need to get a better picture of a judge. That guy looks like he's been pounding down Jack Daniels behind his desk. Had a long day in court, but anyway, sorry about that one. But here's what happens in this court-ordered sale. The debtor, your client, their attorney, files a motion with the court seeking a court-ordered sale. And typically they'll submit to support this motion to get the court's approval is a real estate purchase contract, perhaps a comparative market analysis, or if they have a recent appraisal, I've seen those submitted to support the motion for the court-ordered sale as well. And the reason those are submitted is all the judge cares about is that the sales price represents a fair market value for the property. So if there's a repsi between a willing seller and a willing third-party buyer, the judge, that's typically enough for the judge. The judge may want to see a CMA, though, or even an appraisal to help establish that value, because it's up to him or her to make that determination, and that is that it's a fair market value sale represented by the real estate purchase contract. And then it's up to him or her to make that determination. But that's all they're concerned with. The motion can be made for that motion to sell the property, and the property can be ordered sold free and clear of all liens on that property, all recorded liens or liens specified in the motion and the corresponding order. So when the property is sold this way, when the property is ordered sold by the bankruptcy judge free and clear of the liens are extinguished from the property regardless of the number and the amount of the secured liens on the property. And you could probably tell where I'm going with this one. This can, in essence, be a court-ordered short sale. I'm going to get there in just a second, but backing up just for a moment, because I usually get this question. is when the property is ordered sold this way, free and clear of the liens, it doesn't mean that the debt, the underlying debt secured by those liens goes away. Debt discharge is another issue. It just means that the lien as to that real property interest is extinguished or erased from that property. So whether it's a federal tax lien, a judgment lien for towards an ex-spouse's alimony or child support a child support obligation type of lien, doesn't mean the debt goes away. It just means that that lien securing that debt against this real property asset is extinguished pursuant to this court-ordered sale where the property is ordered sold free and clear of all liens by the bankruptcy judge. And every lien on the property can be extinguished this way. So the sale has to close exactly as outlined and specified in the court order. In other words, if the motion to sell is made based on a REPSI that's attached and has a sales price, and then after the fact, as part of inspections or whatever, or the give and take under the REPSI, under Section 8 of the REPSI, the buyer says, hey, there's a hole in the roof. I want the seller to fix that, or I want a $10,000 credit for that. And we want to adjust the purchase price. If the court has already approved the sale based on the original purchase price, then and then the seller makes an adjustment, the seller's going to have to go back with the seller's attorney and make a new motion to the court for the adjusted purchase price. So that could be sometimes leverage for your sellers when you're trying to get property sold pursuant to court approval, and the judge has approved the sale, and the buyer comes back and says, I want a credit for this or that. You say, hey, look, this is already approved without it. Take it or leave it or whatever. But sometimes that could be leveraged in those situations because the sale has to close exactly as outlined in that court order. I mentioned that the trustee abandonment process to get property sold out of a bankruptcy is more commonly selected than this one. And that the reasons being that the trustee abandonment is relatively informal and is quicker. This process, in contrast, takes a little longer, and it's usually a little more expensive because your seller is going to need their lawyer, the bankruptcy lawyer, to go in and make this motion and to get it approved by the court. The big advantage to this method, though, to this second option, is that this process, as I just mentioned, can essentially be a court-ordered short sale. And that, to me, can provide a definite advantage over the abandonment process. Keep in mind that a trustee will only abandon an asset out of the bankruptcy estate if the secured liens are equal to or exceed the value of the property, which often results in the seller having to negotiate a short sale with those secured creditors with secured liens on the property. In contrast, the judge, when the judge orders this property sold, fair market transaction, free and clear of the liens, the judge takes care of that short sale for you or for your seller. Because the judge can order this property sold free and clear of those liens, so there's no need after the fact to go back and get those creditors to release their liens, particularly creditors who haven't been paid in full for the amount of debt represented by those liens. And everybody wins that way. So I tell agents, in a situation like this where you have an over-encumbered property in terms of secured liens and you have a seller in bankruptcy, don't forget this option too. It's typically a better choice, even though it may take a little longer. It's a little more formal, may cost your client a few more dollars for the bankruptcy lawyer. It eliminates the brain damage that can be associated with a short sale after the fact. And it also eliminates, just with the selfish interest in mind, or just something to tuck away, the need that sometimes agents experience, as you know, when negotiating a short sale, the need of having to defend your commission and avoid taking a less than customary commission. I've never ever seen a bankruptcy judge order a property sold free and clear of liens and ask an agent to take a discount from the customary commission. One time I saw a judge knock an agent back to the customary commission rate because he or she was asking for more. And don't get me wrong, you'll earn your commission 10 times over on these type of transactions. But I've never seen a judge ask a real estate agent to take less than a customary commission when the property is being sold pursuant to a court-ordered sale, which again can accomplish a short sale. Any questions about that? All right, just an example of that. I had this, I know a lot of you are down in Utah County. This was some years ago. One of my favorite transactions of all time because it was pretty complex. And this was a beautiful property up in the northeast corner of Alpine there, up in the foothills. I'm sure it's been subdivided significantly since then. But this was one of my all-time classic bankruptcy court-ordered sale transactions and stories. Here was the situation. It was a big home, not this home. These are just representative only. Well, not the Alpine picture. That's obviously Alpine. But for this particular home, it was a developer who had experienced some financial challenges in Utah County back in the day and went upside down on a couple of developments. And he and his wife ended up filing for bankruptcy. They actually moved to California and just kind of left everything behind, including their house for sale with a listing agent. And this was kind of unique property. It involved multiple acres, had an indoor swimming pool. That's why I had the pool picture. It wasn't outside, it was indoor, still full of water, death trap for the neighbor kids, I feared, but it was still there and they were gone. And the property was listed for sale. This is an actual snapshot, rounded off, of the secured liens that were recorded against this property. That a first mortgage for $1.5 million, a second mortgage for $500,000. There was a third mortgage recorded, and it showed a loan of $350,000 in favor of her father, so the developer's father-in-law. It turns out that that was not a real loan made, that they just recorded the mortgage to try and create the appearance that there was more secured debt recorded against that property than there really was, in an attempt to get other creditors not to lien the property. Well, that failed. It didn't deter anybody from recording secured liens. Most importantly, the IRS, who had, as you could see there, 4 liens, one for $1 million, one for $500,000, one for $250,000, and one for $150,000 against the property. The state tax commission had a lien as well, and then they had a couple of judgment liens. That was a title to the property that they were trying to sell for these sellers who were in bankruptcy at the time. The sum of all the outstanding liens all the outstanding debt, secured by the liens on the property far exceeded the sales price of the property and the commissions owed. So this one was way upside down. So what happened? A buyer came along, made what everybody thought was a fair market value offer to purchase that property. It was accepted by the sellers. A contract for that sale was entered into. And then the seller's lawyers made a motion to the court for an order approving the sale of the property free and clear of those secured liens. And at this time, understand that any of these creditors have the ability to come in and object to that motion. Most commonly, they don't. Again, if it's a fair market value transaction, they won't come in and object, because then the burden becomes theirs to show why it's not a fair market value transaction. In this case, even given the stakes involved, the creditors did not show up. Nobody made an objection to that motion. The fair market value information was submitted to the judge in connection with the motion to support the sales price. And then the judge ordered this property sold free and clear of all the liens. And as a result, as part of this process, this is just an example, the secured liens were wiped off by that court order. As I mentioned, the real estate agents were paid a full commission, and this was for several $1 million, as you might imagine. So the commissions were very significant on this property. And then one of the magical things that happens in this process, where properties sold out of a bankruptcy pursuant to a court-ordered sale, ordering the property sold free and clear of all liens, is you can have what is one of the ugliest titles, at least that I've ever seen, basically wiped clean by this bankruptcy court order. So all those liens are extinguished from the property. And again, one of the cleanest type of titles that can be issued to a buyer, and hopefully buyers will take comfort in this, buying properties from sellers out of bankruptcies, is this title that's issued pursuant to a court order where the property's ordered sold free and clear of all liens. And that's a title that passes to the buyer. Any questions related to that? So those are the 2 ways to get property sold out of bankruptcy. a trustee abandonment, or a court-approved sale by the bankruptcy court judge, and the pros and cons of each. Just an additional, if those aren't enough problems or challenges, and again, you'll earn your commission 10 times over on these things, but there's just some additional problems that I've seen related to getting transactions closed where bankruptcy is going on. First of all, I want to talk about this order of discharge.
Hey, Mike.
Yes.
We have a question from Patty. She asked, what is a judgment lien?
A judgment lien is say, for instance, I had a contract with Corbin and I breached that contract and he sued me in court and he got a judgment against me for, $50,000, the value of that contract. Then once that judgment is entered by the court, Corbin can take that lien and record it in the county recorder's office wherever I have real property, wherever I own real property. And that becomes a lien on my property. That's a secured lien in favor of Corbin that he can even foreclose on if he chooses to try and collect.
And Donnelly also has a question.
Yes, please.
Sorry. So just for clarification, so if someone had a bunch of liens on their property, like the one you just showed, and they wanted to try and get a court-ordered sale, would they just need to hire someone like yourself, like a real estate attorney, to start that process? Or how does someone go about doing that? Or is...
Yeah, great question, Donna Lee. Thanks. And don't apologize. Love the questions. So my role, I'm not a bankruptcy lawyer. I may understand hopefully quite a bit about it as it pertains to transactions. And I'm an attorney for the title company. But yes, they need to hire a lawyer. I would never recommend to anybody that they go at it alone trying to do this in federal court. But usually the party that will represent them is their bankruptcy lawyer, because they've previously retained this lawyer to file the bankruptcy. The bankruptcy lawyer should understand this process, or at least be willing to be coached through it, as we've done from time to time in the past. And that's typically the lawyer that will go in and make the motion for a court-approved sale with the judge. And again, hopefully it's a good lawyer. Hopefully they understand it. If they don't like them and they're not responsive, they can always change horses. So. All right. So at one point during the bankruptcy, the debts of the debtor are discharged, as we talked about up front. They're no longer collectible. The process has pulled out all the non-exempt assets of the debtors and paid them to the creditors, and then the balance of the debts are discharged. A specific list of the discharged debts may be part of the court order of discharge, but the order may be general and refer to all debts that are dischargeable. But keep in mind, there are certain types of debts that are not dischargeable, such as alimony and child support debts, student loan debts, and tax debts. They're not dischargeable. Here's a challenge that we run into as it pertains to discharged debts, though, and liens representing those debts. Sometimes we'll issue a title insurance commitment, and listed on Schedule B, Section 2 will be these judgment liens, these tax liens, representing debts that were perhaps discharged in the bankruptcy. And the immediate response of the seller or client, even at this point often out of bankruptcy, is they'll say those debts were taken care of in the bankruptcy. And the response is true, the debt was discharged in the bankruptcy, if in fact it was. But the order discharging the debt, and that's why I love the judgment lien question, an order discharging the debt does not translate into an order that removes any liens securing those debts from the real property owned by the debtor. What has to happen there is there has to be a separate order avoiding or stripping the lien from the property that's evidenced by that debt. And this is very frustrating to sellers trying to sell homes in a post-bankruptcy situation or post-discharge situation where they have to deal with the secured liens pertaining to debts that were previously discharged into bankruptcy. And this makes no sense to them, and understandably so. So here's the diagram of that issue. It's like we have the bankruptcy case filed, but there were judgment liens that were recorded against the real property asset of the debtor prior to the bankruptcy. As we've discussed, at one point during the bankruptcy, an order is issued discharging those debts represented by those liens. So these are judgment debts that are discharged, and there are liens recorded against the property related to those judgment debts, but the debts themselves are discharged. Well, just the order of discharging the debts doesn't translate automatically into a removal of the lien securing those debts against the real property. And this, again, is brain damage for your sellers, and frustrating, and we understand it. So here's just my handy dandy example. Sorry about the graphic at the bottom. And they're not advertising that these days, unfortunately, but a common debtor in a bankruptcy is Intermountain Healthcare, no secret there, RC Willey, collections agencies collecting for somebody else, credit card company, a bank, even with a second mortgage. My little diagram there at the bottom is that people get enticed into stores, perhaps RC Willey's, they advertise a hot dog and a Coke on certain holidays, and you go in and often you come out with new electronics, right? And that's the idea. But anyway, let's just take this graph and let's look at these debts owed by this debtor in bankruptcy, and let's look at the RC Willey debt first. Well, with the RC Willey debt, let's say that RC Willey has understandably and rightfully so gone after that debtor and taken them to court and received a judgment related to that debt. And then, as we talked about in the example between me and Corbin, that RC Willey has taken and recorded that judgment against this debtor's home. Intermountain, in contrast, wasn't as far along. They just had the debt owed for uninsured medical expenses, but they still had not been to court. They don't have a judgment lien. The collection agency does have a judgment lien. The credit card company doesn't. The bank with a second mortgage, of course, does. In a situation where debts are discharged in the bankruptcy, all of these debts are dischargeable, meaning the debtor does not have to pay them going forward. But those former creditors who had judgment liens representing those debts on the property prior to the bankruptcy still have those liens. And it makes no sense whatsoever, but the law requires this debtor to, typically as part of the bankruptcy proceeding, get a release of those judgment liens, even though the underlying debts were discharged. And that is what drives people nuts. Here's an example of an actual order on a motion to avoid a judgment lien. This is a separate motion that has to be made during the course of the bankruptcy, and it's usually made about the time the order discharging debts is entered. An attorney on his or her game will also make a motion to the court for an order avoiding or stripping the lien securing that discharge judgment. But very often this does not happen. Stacey,
yes,
please.
I was just going to mention that. This is where the most critical part is that I have found on several occasions where people have gone through bankruptcy. They haven't fully understand the situation with abandonment or stripping the lien, and they get frustrated because they think that their bankruptcy has already cleared all of that, and it actually doesn't. And so I've noticed, though, with these transactions that a lot of the times the bankruptcy attorneys are not doing it initially with the bankruptcy. They're waiting and they get notification later. It's another way for them to, I guess, make money and reopen up the bankruptcy to have those liens stripped. And so it takes a lot longer. It could take up to 3 months to 4 months that I've had in my experience. And so we need to make sure that the consumer is educated enough to request that during the bankruptcy. Otherwise, like I mentioned, I've seen where they're not, and then we have to go back and reopen it, and it costs, additional money.
Thanks, Stacey. You'll see the judge on this order is Kim Mosier. And I actually, long ago, taught a continuing legal education class. I was on a panel with some other attorneys, and he at the time was on the panel, and he was an attorney practicing bankruptcy law, and he subsequently became a trustee, and then now he's a judge. A very good one too. And he asked the attorney, he was talking about this very concept with the attorneys, 150 attorneys there, and he said, why don't you make a motion for an order discharging judgment liens at the same time the order for discharging the underlying debts represented by these liens is issued? And some of them said, you know, back to this picture, they said, well, we don't know which of the debts or have been reduced to judgment liens. For instance, you know, to us, we just see the list of debts. There's no difference between the RC Willey debt and the Intermountain Healthcare debt. Whereas from a title standpoint, there's a huge difference. It's significant because one has a judgment lien on it. And he said, well, get a title insurance commitment when you're in the middle of bankruptcy, and then you'll know, or just get a motion for order, you know, removing all liens, avoiding all liens. And he got on him, and he said he thought that this was malpractice, that they didn't do it, and really kind of, well, he didn't lose his cool, but he kind of scolded the attorneys, and he said, we need to see more of these. I don't know if it did any good on that crew, but in the years since, I don't know that any more attorneys have figured this out, and that's unfortunate because you know, it's a challenge, as Stacey mentioned.
Yeah, because I would assume that it would all be included within the bankruptcy as part of that process. You know, if they are discharging it, why wouldn't they just, you know, follow through with the rest of it?
Exactly. So here's one, and Stacey's had these as well. I saw this one not too long ago. The debtor post-bankruptcy, debt discharged, faced a sale of a property an $80,000 judgment lien representing a debt that had been discharged in the bankruptcy. She told her agent, famous last words, this was taken care of in the bankruptcy, and that's partially right. The debt itself was discharged, but the lien was not avoided or stripped pursuant to an order of the court. So she'd listed her property for sale. This lien showed up on the title insurance commitment and had to be addressed. And unfortunately, she's left in a situation. Well, she went back to her lawyer and said, why didn't you take care of this in the bankruptcy? As the bankruptcy judge did to some other lawyers that day I was there in that seminar. But she was frustrated, obviously, very upset, because what has to happen in the situation is the debtor's forced to go back to that creditor and to get the lien released, hat in hand, has to ask for a release. Well, how responsive do you think the creditors are in this situation? You know, they're not.
They're not, and they don't want it released.
Yeah, and sometimes they'll take what I call blood money. You know, they'll negotiate a settlement, or, you know, the alternative, and that's what happened here. Is Stacey mentioned, this one was so significant that she went back to her lawyer and got her lawyer to go back, reopen the case, and get the separate order avoiding the lien. And that could be expensive. In this case, she did threaten malpractice to the lawyer, and the lawyer did it for free. But that's the challenge that they have and that we all face.
Well, and we find a lot whenever I see, you know, Amex, American Express, they are terrible. They will just hold it up and they don't want to release it, and they'll try to come back and try to collect and use that as a form of, you know, blackmail, so to speak, you know.
Hey, thanks, Stacey, for that.
I need to do another keyword really quick.
Oh, please.
Title gout.
Those are two keywords.
Two keywords, sorry. There you go.
All right, I'm out of time, but I just want to briefly talk about this one because we see it on occasion. And this is a situation where you have two parties that own a house, usually a husband and a wife. Sometimes they're divorced at that point, but one of them's filed a petition for bankruptcy and one of them has not. In that situation, we have to deal with this, and it's almost like two transactions in one, where you have the one seller who's in bankruptcy. You have to deal with everything we've talked about today, whereas the other party is not, and it's just a typical sale with him or her. So we deal with those. The most recent one I had was really unfortunate, and I'll tell you this one. It was a short sale situation. And had a former husband and wife who were married, bought this house, borrowed money to buy this house, and both signed the note and the deed of trust, and the deed of trust had been recorded on the house, and they subsequently got divorced. As part of the divorce decree, he was allowed to stay in the home. She still was a co-owner of the home, and he was supposed to make the mortgage payments going forward. He was a pharmacist, unfortunately, started writing prescriptions to himself. Addiction can be a demon, as we all know. And eventually lost his job, lost his sobriety, lost his license and found himself in a very depressed, reclusive state. In the meantime, the house started to go into disrepair and stopped making the mortgage payments. To keep her credit alive or healthy, she started to make the mortgage payments, but then she went about trying to get the house sold, called a listing agent who contacted me and said, what are the chances here of this getting sold? And here was the rub. He at one point filed a petition for bankruptcy. So I said, someday, somehow, this is going to get worked out. This is going to get sold. But it's going to be an uphill battle because you're dealing with his issues and everything we've talked about today related to bankruptcies, including an automatic stay that prevented the lender from at least talking to him about a possible short sale, which was what they were facing at that point. The agent decided to take the listing and did, and it took months to get this resolved because what she was dealing with, the agent, was two clients, one in a tough situation personally and in bankruptcy and having to deal with all the bankruptcy issues, and another client who was just trying to get the property sold and get her loan paid off so her credit wouldn't be ruined. This is a very, very tough transaction. We run into these from time to time, and if you're an agent on one of these, you'll earn your commission many times over, and I admire you. So anyway, good luck with that. We're out of time for questions. I'm sorry, but I don't want to keep you any longer than you have to be. But just a word of thanks from us for participating in this new format, at least for us, these electronic classes. I definitely prefer the one-on-one engagement, but we'll take what we can get during the time of COVID-19. But you've all been awesome. Thanks for your participation. If you're using this, thanks very much for your support.
Yes, thank you.
We work with the best of the best, including Stacey and Corbin. We have an amazing office there in Orem, as well as 13 other offices here in the state, and have the great privilege of working with them. If we can be a resource to you, we would love to be that. If you're not using this, please give us a shot. We'd love to show you that we're the best out there, and I truly believe that we are. But I am finished. Thank you all. Have a wonderful day, and all the best with success on your transactions, especially now.
Yes, thank you so much for attending. It was good to see all of your faces, some new faces.
Yes.
Watch out for some of our additional CE classes that we will be posting online. And then also we do our Title Tip Tuesday. If you're interested in that, just let me know when you send the email. That gives information on kind of what Mike just spoke about, but different things to keep you informed and your customers informed as well. If you haven't seen my information on the side in the chat, let me know. Otherwise, thanks again, and we're here as a resource to you.
Yes, thank you guys. We appreciate it.
Thank you.
Okay. See you
Have
later.
a great
Have a
day.
good day.
Thank you.
Stay
Bye.
safe and healthy.
Thank you, Mike.
Thanks, guys.
Thanks, Mike.
Okay.
Corbin, thank you.